Thank you. Good morning again, Mr. President, Your Honors. It is a great privilege to appear before you today. As my colleagues indicated, I will focus my remarks on your Group B questions. Before I do so, I would like to tell you briefly about our client, Mohammed Abdullah Salah al-Asad, a victim of the U.S. torture program, whom we represent by and through his surviving family, and on whose behalf my colleagues and I appear today. Our client is one of many victims of the Coordinated Global Torture and Extraordinary Rendition Program run by the United States, with a hub, or as Ms. Gallagher said, its epicenter in Afghanistan, which targeted individuals suspected, often wrongfully, as in the case of our client, of ties to al-Qaeda, the Taliban, or other groups. Our client's horrific experience of torture and secret incommunicado detention is emblematic of why this calculated systematic abuse should be the subject of a criminal investigation by this court. In December 2003, Mr. al-Asad, a Yemeni national and successful businessman living in Tanzania, was seized from his home in front of his family by Tanzanian officials and secretly flown to Djibouti. Djibouti, a state party to the Rome Statute, held our client incommunicado for 2 weeks in one of their local facilities, where he was interrogated by an American official and threatened with death. He was then handed over to U.S. custody on the airport tarmac, where he was subjected to capture shock, a brutal procedure constituting torture that was systematically deployed by the CIA to foster what it termed learned helplessness, a sense of total subjection to U.S. control. Mr. al-Asad was stripped naked, sexually assaulted, diapered, chained, and strapped down to the floor of an airplane. He was then flown to Afghanistan, where he was held incommunicado in 3 different facilities. While there, his American captors subjected him to sensory deprivation and dietary manipulation, shackled him in painful positions, prevented him from sleeping, held him in isolation, and blocked him from sunlight. After a 1.5 years, he was released to Yemeni custody. Since then, Mr. al-Asad and his family have tried in vain to seek justice. Tragically, Mr. al-Asad passed away 3 years ago. Our client's surviving family, like many of the victims represented here today, has turned to the ICC as a last resort after unsuccessfully seeking accountability through numerous channels for more than 12 years. The pretrial chamber's decision shuts the door of this court on our client and other victims similarly situated by erroneously finding that the crimes which they suffered fall outside of the court's jurisdiction, and by completely foreclosing any investigation, let alone prosecution. Turning now to your questions, all of which we answer in the affirmative, the LRVs submit that the impugned decision is unequivocally a decision with respect to jurisdiction within the meaning of Article 82(1)(a). The impugned decision satisfies the standard articulated in this chamber's 2011 decision in the Kenya appeal, because the pretrial chamber, as Mr. Gaynor said, issued a ruling specifically on the jurisdiction of the court. First, it is axiomatic that a decision that denies authorization to exercise jurisdiction is by nature a decision with respect to jurisdiction. An Article 15.4 decision determines whether the prosecutor may exercise jurisdiction pursuant to Article 13C, and if so, confirms the scope of that exercise. In no way can such a decision be said to have merely an indirect or tangential link to jurisdiction. Second, here, the pretrial chamber made express jurisdictional findings, which it set out under headings of jurisdiction ratione loci and ratione materiae.
Excuse me, counsel, please slow down a little.
Thank you, excuse me.
Thank you.
These findings are unequivocally jurisdictional. As Mr. Gaynor mentioned, they erroneously and prematurely exclude from the court's jurisdiction certain categories of crimes and victims encompassed by the prosecutor's request based on concepts set out in Articles 5 and 12 of the statute. For example, in paragraph 55 of the decision, the pretrial chamber states in no uncertain terms, and I quote, "The alleged war crimes whose victims were captured outside Afghanistan fall out of the court's jurisdiction," end quote. This ruling placed many of the crimes committed against victims of the U.S. torture program represented by the LRVs outside any investigation or eventual prosecution. These specific jurisdictional findings are not merely dicta or unrelated to the operative part of the decision. As Mr. Guarilla said, they were necessary steps to reach the analysis of the interests of justice, but they were not merely steps. As even the prosecution acknowledges, they materially affected and are inextricably linked to the pretrial chamber's understanding of the scope of the investigation and its subsequent appreciation of whether that investigation would serve the interest of justice. The operative part of a decision and its nature are defined by the substance of the issue determined, not the chamber's subjective characterization of its disposition. Here, the substance of the decision, and indeed of the interest of justice analysis, is the refusal to authorize the prosecutor's exercise of jurisdiction under Article 13C, despite having found the relevant requirements were met as regards to both jurisdiction and admissibility. Moreover, if this chamber were to reverse or vacate the pretrial chamber's interests of justice analysis, as all appellants argue it should, these erroneous determinations with respect to jurisdiction would stand unless corrected. Concluding that the decision was one with respect to jurisdiction is entirely consistent with prior jurisprudence of this chamber. First, the decision is fundamentally different in nature from other decisions that this chamber has held to be too indirectly or tangentially linked to admissibility or jurisdiction. As elaborated in footnote 68 of our September 30th appeal brief, those other decisions involved matters falling outside of Part 2 of the statute, ranging from a state's request for assistance in its investigation to the postponement of surrender and the court's competency to release witnesses. The impugned decision here, which rules on the permitted scope of the investigation and excludes per se certain alleged criminal conduct and categories of victims, is more like, we submit, the 26 October 2011 Mbarashumana and the 22nd March 2016 Ntaganda appeals. In those appeals, this chamber recognized as jurisdictional in nature a decision regarding the scope of a situation referred to the court by a state party, an issue that goes to the exercise of jurisdiction under Article 13, and a decision regarding the exclusion of categories of acts and victims from the ambit of the court or its subject matter jurisdiction. The 6 November 2015 Comoros appeal decision does not require a contrary result here for several reasons. First,
you have 2 minutes left.
Thank you. First, by its plain language, the decision appealed in Comoros only requested the prosecutor reconsider whether there was a reasonable basis to open an investigation. It did not make any determination about jurisdiction or admissibility. Second, in evaluating the nature of the decision at issue in Comoros, the appeals chamber looked to the power that the pretrial chamber exercised under the statute. Doing so highlights the difference between that decision and the decision at issue here. Under Article 53A, a pretrial chamber is limited to requesting that the prosecutor reconsider her decision. It does not have authority to make its own decision. In contrast, under 15.4, the pretrial chamber is expressly mandated to decide whether to grant authorization. Third, the pretrial chamber decision at issue in the Comoros appeal was explicitly not the last word on the matter. It was a request to the prosecutor to take further action. In contrast, the decision here purports to be final as to whether or not the prosecution may exercise jurisdiction to investigate the facts put forward in its request. Article 15.5 does not change that. A subsequent request under Article 15.5, based on new facts or evidence, would be an entirely new and separate request from that which the pretrial chamber disposed of. Moreover, the prosecutor has expressly said in paragraph 18 of her October 22nd response to victims' appeal briefs quote, if the pretrial chamber had ruled certain matters to be out of the court's jurisdiction, then it would manifestly not be proper for the prosecutor to return to that same chamber with those same matters. That is precisely what the pretrial chamber did here with respect to crimes committed against our clients and others who were captured outside of Afghanistan. Finally,
excuse me, counsel, to interrupt you. Please conclude. Your time is up.
Thank you. With Mr. President's permission, I'm concluding on your final question, turning to question C. The pretrial chamber's limitation of the scope of the investigation is a decision with respect to jurisdiction, confining the investigation to only those incidents specifically included in the prosecutor's request and incidents closely linked to them, not only defeats the very purpose of an investigation, but also places criminal conduct which squarely falls under the statute beyond the reach of the prosecutor and, by extension, the court. Circumscribing the prosecutor's investigative jurisdiction in this way is most certainly a decision with respect to jurisdiction and thus appealable under Article 82(1)(a). Thank you.